In today's courtroom session, we see the full spectrum of street-level justice, from petty theft and reckless racing to drunk driving and mental health struggles. Each defendant stands before the judge with a story, but the law has no patience for excuses. Judge Fletcher makes it clear, every careless act ripples through the community. A stolen item, a dangerous joyride, a violent threat, each one threatens someone's safety. This isn't just about punishment, it's about accountability. Watch closely how justice unfolds when impulse collides with consequence, and excuses meet the law.
You were Alan Villisana.
Sir?
Mr. Villisana, you were charged with 2 cases. You were charged with theft. You were also charged with racing on a highway. On both of those cases, you were facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
The theft or the racing, which
Yeah,
was
start on the theft because it's the earlier one, yeah.
on January 1st, 2025, officers were dispatched to a shoplifter call at a Target in Harris County, Texas. The complainant, the loss prevention employee, called the officer regarding a theft in progress at the location and observed a Hispanic male wearing a tan hoodie and black shorts making a selection and removed the security tape from a JBL speaker box and placed other products inside a shopping cart. The complainant proceeded to keep the surveillance on the male and observed the defendant proceed to exit past all points of sale without any intent to pay the items. The officer reviewed the surveillance and observed the complainant make contact with the defendant at the front entrance and attempted to retrieve the stolen items, and the defendant proceeded to leave the Target and enter a black Chevrolet Spark. With the assistance of a license plate reader and TLO, the officer determined the motor vehicle to be driven by the defendant and obtained a Texas driver's license, which the officer believed completely matched the Hispanic male captured on the surveillance footage. The total taken was $499.03.
Okay. On the racing.
Now, the second charge flips from property to danger. Racing at 120 miles per hour on public roads isn't just speeding, it's gambling with lives. 2 cars weave through traffic, cut off others, even drive the shoulder. Officers can barely keep sight. When the defendant admits he would have fled if his tank wasn't empty, it turns a reckless act into willful defiance. The courtroom tone hardens. This isn't a ticket. It's a warning to everyone watching the roads.
Please.
Yes, Your Honor. On March 15th, 2025, the officers observed a black Toyota Camry and a silver Chrysler sedan traveling at a high rate of speed on the main lanes of the Katy Freeway. Officers attempted to catch up to the motor vehicles traveling 120 miles per hour to keep the motor vehicles in sight, but both motor vehicles were still out gaining speed. The posted speed limit was 65 miles per hour. Both the defendant and the silver Chrysler were racing in competition side by side at points, with both motor vehicles accelerating at a high rate of speed, attempting to outdistance and outgain each other. While the defendant and the Chrysler were racing, they were making evasive lane changes and failing to signal lane change, cutting off multiple motor vehicles to get around traffic, causing victims with their motor vehicles to take evasive actions to avoid collisions. The defendant's motor vehicle at one point drove on the right shoulder to pass vehicles in the right lane and was in front of the silver Chrysler. A traffic stop was initiated.
So driving on the shoulder
Yes,
to
on
get.
A traffic stop was initiated and the officer made contact with the defendant, who was the driver. The defendant admitted that he was racing with the other vehicle and that this was not his first time racing, but his first time arrested, and that he would have ran from the officers if he had more gas in the motor vehicle.
Listen carefully to the judge's phrasing. I'll do everything in my power to protect my city. That line captures his philosophy. Public safety first, sympathy second. The defendant is barred from driving, alcohol, and even entering Target stores. Every word is both an order and a deterrent. The goal: stop the next incident before it happens. This moment sets the standard for every case that follows.
Mr. Villisana, I'm going to find that there's probable cause to go forward on both of your cases. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication, I'm going to randomly test you. If I find that you're using, I will revoke the bond on both of your cases and I'm going to put you in jail. I'm also ordering you now not to drive. You will be signing an affidavit with me today promising me you're not going to drive. Do you understand?
For how long?
While this case is open, and if I find that you do, likewise, it's not going to go well for you. Do you understand?
Yeah.
Can you print me out more affidavits, please? You're not to go to any target whatsoever as well. If I find that you pick up a third case, it's really not going to go well for you. Do you understand? I'm going to do everything in my power to protect my city at all costs. And if that means putting you in jail and making your bonds high, I'll do it in a heartbeat. Do you understand? Do you have the ability to hire a lawyer, or would you like to apply for a court-appointed lawyer?
I didn't have a job right now, so I can't.
Okay. Deputy Miranda's going to give you an application. I'll have you fill it out and I'll take a look at it with it. Hey, I'm not done talking to you. I'll have you take a look at I'll have you fill it out. I'll take a look at it. I'm going to have you sign a receipt with Victoria. I'm going to have you come back because I'm going to have you sign an affidavit with me today promising me you're not going to drive. And then you'll get with Fleischer for your bond conditions.
I won't be able to come back. I don't have a ride.
Figure it out. I'll get you a lawyer and we'll start talking. But I don't want any more problems. Do you understand?
No, I haven't been in problems like 5 years. This is the first time I had a case since 5.
So, please.
A repeat DWI is no longer about a mistake. It's about pattern and risk. The officer notes weaving between lanes, slurred speech, confusion, and the smell of alcohol. When the driver refuses a breath test, a warrant authorizes a blood draw, a legal pivot that preserves evidence. The judge's approach is blunt. Remove the keys, install an ignition interlock, and warn of immigration consequences. It's procedural, but also preventive proof that courts view DWI not as a private issue, but a public hazard.
Good morning, Mr. Alipio.
Yes.
Sir, you were charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On March 13th, 2025, an officer observed a blue Ford F-250 driving at a high rate of speed. The officer paced the Ford driving 79 miles per hour in a 60-mile-per-hour zone. The officer observed the vehicle to fail to maintain a single lane, driving over a solid dash line, and driving between two lanes with other motor vehicles in the area when the vehicle failed to maintain the single lane. A traffic stop was initiated. The officer made contact with the defendant, the driver and sole occupant of the vehicle. The officer observed the defendant to have slurred speech. The defendant stated he drank one alcoholic drink prior to the traffic stop. The officer observed the defendant to be staggering while walking, using the motor vehicle for support, and the defendant to have the mild odor of alcohol upon his breath. The defendant appeared confused, and the officer had to repeat himself multiple times. SFSTs were conducted. 6 out of 6 clues were observed on the HGN. 2 out of 8 clues observed on the walk and turn. 3 out of 4 clues observed on the one-leg stand. The defendant stated he drank 2 to 3 alcoholic drinks prior to the traffic stop. The defendant was arrested. An inventory search was conducted of the defendant's vehicle, and the officer observed a warm to the touch white cup in the center console.
Alcohol while driving?
3 to 3/4 full while with the smell of an alcoholic beverage.
Tenía un olor de una bebida
The
fuerte.
defendant was
Pero
read the
mandaba la
DIC
bebida
and refused the
y
breath
se negó
test.
al test de aliento.
A blood search warrant was
Así
signed and
era.
executed.
Demostrarles.
Mr. Alipio,
Señora
I would hope and that you would recognize it's elementary that you're not to have alcohol in the car while you are driving. I'm going to find that there is sufficient probable cause to go forward with your case.
Here, the judge orders a portable alcohol monitor, a small device that measures breath samples daily. It's not punishment. It's proof. This reflects the court's shift toward data-driven accountability. Instead of trusting words, the system demands readings. The documentary lesson? Technology now serves as both parole officer and alibi. Comply and you keep freedom. Cheat, and the data convicts you faster than any witness.
I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will put you in jail. I am now also taking away your privilege to drive. You are not allowed to drive. If I find that you do, because I will have you sign an affidavit, a promise with me that you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive, likewise, you will go to jail. I do not know what your immigration status is, but if you were not in this country with permission and you go to jail and immigration finds you, they will put an immigration detainer on you and you will be stuck like Chuck in custody until this case is over with, and then you get shipped off to immigration. Do you understand?
Yes.
I am sending notice to DPS that there is now a restriction on you that you are not to drive any vehicle that doesn't have an ignition interlock on it. If you were caught driving a vehicle and it does not have an ignition interlock, every officer in this state will know to arrest you and put you in jail. Do you understand?
¿Usted lo entiende? Yes.
Your Honor, just to clarify, so he can drive so long as he has a guardian in?
No, I'm taking away, he's not allowed to drive at all.
Would you consider reinstating his ability to drive because owns his own business?
I'm not ready yet. All I know is that he's got alcohol allegedly in the car while he's driving, and it's a second offense. Look at me, Mr. Alipio.
Examíname, señor.
Do not drive. Do you understand?
Yes. Yes, sir.
Because of this restriction, you will now be required to obtain a portable device that you're going to take with you everywhere you go to prove to me that you are not consuming alcohol. I don't know if you have a problem with drugs or alcohol. If you do, now is the time for you to address it. Because if I see it becomes a problem, I'm going to address it for you. And I promise you're not going to like the way that I do it.
No, te va a gustar como lo.
Do you understand?
¿Te lo entiende?
Yes.
Yes.
Because you have a lawyer, I will waive your appearance. That means that you don't have to waste your time coming to court. But it is your responsibility to stay in touch with Lee. If she tells me that she can't get a hold of you because you're ducking and dodging phone calls, you're playing games, you're not responding to her, likewise, I will issue a warrant for your arrest. I'm going to do everything in my power to protect my street at all costs. And I have no qualms about putting you in custody. If you don't believe me, ask Lee. She knows. For now, I will have you come up here, swear to us that you're not going to drive. After that, you'll get to Victoria where we will have you sign a reset. After that, you'll get with Fleischer for your bond conditions. And after that, you'll be free to go. It's not forever, but I want to know that you truly appreciates and not just, oh, I'm sorry.
Yes, Your Honor, his prior DWI was in 2003, so he had not had alcohol in a long time.
How do we know?
¿Cómo sabemos?
How many times has he not been caught that we just don't know?
No.
I don't know, but all I know is he's got alcohol in the car. He has a prior DWI, so he's already on notice of what you can and can't do. I have a problem. So
Yes, Your Honor.
just proactivity goes a long way.
Yes, Your Honor.
All right. Good luck to you, Michelle.
This third case reveals a different side of justice. When the issue isn't defiance, but cognition. The defendant has a terroristic threat charge, but his lawyer doubts he truly understands what's happening. The judge pauses, orders a T-RAS clinical evaluation, and stresses that dumping someone with untreated mental issues to the wolves helps no one. It's rare to see compassion and caution coexist this clearly. The takeaway, mental fitness isn't mercy. It's due process.
I was here for Mr. Flores, Adrian Flores. He's in the holdover. He's got a terroristic threat on a serious bodily injury charge. Represent me.
Hi, how are you?
Harold, what would you like? What are we doing?
Just today was the day we're going to come back for the mental health evaluation, and they just sent it to me this morning. Haven't had a chance to read all of it. They did say he was competent, but I still think something's right with him. I talked to him.
So get a second opinion. You know, if you need money for a second evaluation, I'll give you money.
And I don't know. I mean, it might be he's competent, but just something's not correct, with our thinking and reasoning when I was.
Are you able to communicate with them?
I am. Well, just for instance,
Limited fashion or something, or what?
Sorry?
In a limited fashion?
he communicate. Just for instance, I was just told, well, I just want to go ahead and work it out because then I'm going to hire an attorney and we're going to get them all dismissed later. I'm like, no,
Yeah, it doesn't work.
if we're going to do this, we got to do it now. We have to decide if we're going to trial now. And
That's
then
the, I want to get out as quick as possible and then
kind of, but that was a little more than that though. Just,
to talk to him.
I guess it would be a safe thing. Just explain to them what's going on.
Do you mind bringing out Mr. Flores? Do you need a translator?
No, sir.
Adrian Flores, please.
And I think he understands now, but it just might be a misconception, maybe jailhouse lawyer talk or not understanding his
I don't know.
cases.
Does he have his pending in the 220? This case?
No other cases pending as far as I know.
Good morning, Mr. Flores. How are you?
Good today.
Good. The reason that you are still in custody is that we gave you a PR bond and you take off. You don't come back to court. This has not happened but once. It has happened already multiple times. So that's why I can't just continue to give you PR bonds. When you do, you just take off. The only thing I need you to understand is that, when you plead guilty to something, it sticks with you forever. You cannot try to plead guilty to something, get out and try to change it or do this or do that. This is when you do this, when you accept a plea bargain, it stays.
Judge, Your Honor, I'm truly sorry for what I've done, like my whole life. I just asked for another PR bond. I'll make it a court. I actually call my mom, see if I could stay with her until she drops me off at court, and whatever they say from there, if I'm guilty or not guilty, I'll plead guilty. Or if I'm innocent, I'll
Where
plead
you living
innocent.
now?
My mom stays in Tomball now.
No. Are you living on the street or are you living?
I'm homeless, but I've actually talked to my mom, and me and her are actually going into a good relationship now,
Did you just get picked up?
like mother and son. And yeah, they caught me at the airport, and
Look, I don't want you to talk about the case. The thing is that I don't want to continue to give someone a PR bond if you're just going to go to the streets. The streets are not a safe place.
I won't go back to the street. The streets
I know.
aren't for me anymore, man. I don't want to be in the street. I don't want to be homeless anymore. And I've talked to my mom. She's doing real good, and she actually wants me to be around, pay the bills, and and own a house of my own.
Let's do this. Why don't we do a T-RAS to see how we go forward? Because I don't know, and we can have the clinicians evaluate them to see how we go forward.
First?
If you want to do an independent one, I'm happy to give you money for you to do it. Or like I would suggest is just do a T-RAS to see where do we go? Because I don't know, but having clinicians talk to him, might be the best way to go to see how we go forward. Because the problem is, Harold, is if we just throw him out to the streets, we're throwing him out to the wolves. You know, if he doesn't have a place to go to, or just, you know. Whereas if we have him T-RAS, we can try to get down to what the true issue is and why it keeps happening, and then we'll figure out a plan, you know? So you just let me know whatever you want to do. I'm happy to do it.
So just we do the T-RAS, we just set that up with the CLO or?
Yeah, so we'll have Shatori set it up and we'll do it. We can expedite it so it gets done within the next couple of days, so he's not just lingering.
Judge, as competency is also good then?
Yeah, competent. Yeah,
Burr?
so we can get it done. And then that'll really tell us, perhaps it needs to be in mental health court. I don't know. But that's what we can get the T-RAS for.
So what do you think, there's 2 weeks or?
No, not even a week. A week. Okay,
Thank you.
all right, Mr. Flores. Good morning, Mr. Lundy.
The hit and run shows the quiet logic of accountability. Lundy admits he fled the crash scene because of an old warrant. Not injury, not panic, just avoidance. The judge responds with calibrated firmness. No driving unless insured and licensed. It's proportionate justice, corrective, not crushing. The system doesn't just punish the act. It measures the mindset behind it.
Sir, you're charged with failure to stop and give information, which is leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 12th, 2025, at approximately 4:45 p.m., an officer was dispatched to an FSGI call. Upon arrival, the officer spoke to the complainant, who stated he was traveling north on FM when a vehicle crashed into his vehicle. The driver then fled the scene without exchanging information. Complaining witness to the passenger stated that they were rear-ended, causing the defendant's vehicle to crash into a ditch. Defendant then approached them to check on their welfare, and once he saw they were unharmed, the defendant fled the scene on foot. The officer observed significant rear-end damage to the complainant's vehicle. The complainant provided a description of the defendant, and the officer ran the license plate and found the registered owners were Michael Lundy and Dylan Lundy. On March 13th, 2025, the officer received a call from Dylan Lundy, who wished to provide a voluntary statement regarding the incident. The defendant admitted to crashing into the complainant's vehicle and to fleeing on foot because he believed he had an open warrant for failure to appear for a window tint violation. The complainant positively identified the defendant by photograph. The estimated cost to repair was over $200, as the complainant believed their vehicle was totaled.
Okay. Can you run his license, please? And does he have any open cases anywhere? You can run an NCIC.
His driver's license is eligible, and I normally don't take note of Class C violations, but I do.
No, I don't care about Class C.
Right.
Didn't-
Um,
No, I don't care.
He does not have any open
Okay.
cases at the moment.
Got it. All right, Mr. Lundy, I'm going to find there's sufficient probable cause to go forward with the case. The only condition I'm placing on you now is you are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you do not have car insurance, you may not drive. You understand?
Yes, sir.
Okay, I will waive your appearance because you have a lawyer. Just stay in contact with Will. He'll tell you if and when you have to come back to court. I'll have you sign a receipt, Victoria. We'll have you take a seat while we get your conditions. You'll sign it and then you'll be free to go.
Thank you, Judge.
Don't pick up any new cases.
Yes, sir.
Is that free pro bono?
After 4 defendants, one pattern is undeniable. The judge's consistency. Whether it's theft, speed, alcohol, or fear, his message is the same: protect the streets. Each ruling balances individual rights with collective safety. For the audience, this isn't random sentencing, it's a civic operating system in real time. Every warning, every affidavit, every no-drive order is part of the same mission. Keep chaos out of motion before it hits another headline.